Modern Real Estate Practice, page 104. Will take title as joint tenants or tenants in common. This is especially important when specific wording is necessary to create a joint tenancy. Consideration. A valid deed must contain a clause acknowledging that the grantor has received some form of consideration, that is, something in return for deeding the described property to the grantee. Generally, the amount of consideration is stated in dollars. When a deed conveys real estate as a gift to a relative, love and affection may be sufficient consideration. In most states, it is customary to recite a nominal consideration, such as $10, and other good and valuable consideration. Granting clause. A deed must contain a granting clause, or words of conveyance, that states the grantor's intention to convey the property. Depending on the type of deed and the obligations agreed to by the grantor, the words would be similar to one of the following: I, JKL, convey and warrant. I, JKL, remise, release, alienate, and convey. I, JKL, grant, bargain, and sell. I, JKL, remise, release, and quitclaim. A deed that conveys the grantor's entire fee simple interest usually contains words such as to ABC and to her heirs and assigns forever. If less than the grantor's complete fee simple interest is conveyed, such as a life estate, the wording must indicate that less than a full interest is being conveyed. For example, to ABC for the duration of her natural life. Habendum clause. When it is necessary to define or explain the ownership to be enjoyed by the grantee, a habendum clause may follow the granting clause. The habendum clause begins with the words to have and to hold. Its provisions must agree with those stated in the granting clause. For example, if a grantor conveys a timeshare interest or an interest less than fee simple absolute, the habendum clause would specify the owner's rights as well as how those rights are limited, a specific time frame, or certain prohibited activities, for instance. Legal description of real estate. To conform to the intent of the grantor, a deed must contain an accurate legal description of the real estate conveyed. Land is considered adequately described if a professional surveyor can locate the property and accurately mark its boundaries using the description. Exemptions and reservations. A deed may specifically note an encumbrances, reservations, or limitations that affect the title being conveyed. This might include such things as restrictions and easements that run with the land. In addition to citing existing encumbrances, a grantor may reserve some right in the land, such as an easement for the grantor's use. A grantor may also place certain restrictions on a grantee's use of the property. Developers often restrict the number of houses that may be built on each lot in a subdivision. Such private restrictions must be stated in the deed or contained in a previously recorded document, such as the subdivider's master deed. that is expressly referred to in the deed. Many of these deed restrictions have time limits and often include renewal clauses. Signature of grantor. To be valid, a deed must be signed by all grantors named in the deed. Some states also require witnesses to or notarization of the grantor's signature, as described below.